Thank you. We welcome you to the Court of Appeals this morning. I'm Judge Luthi, glad to be joined by my colleagues, Judge Mortensen on my left and Judge Tenney on my right. We'll be considering 4 matters today, and in 2 of them we'll be hearing oral argument. The first case for oral argument is Wilson versus Wilson, our case number 2024-0444. Let's go ahead and take appearances of counsel on that one.
Emily Adams for Lisa Wilson.
Thank you, Ms. Adams.
Julie Nelson and Aaron Harris for appellee Brad Wilson.
Thank you, Ms. Nelson. You two both are familiar with how we work, and it looks like you've reserved 3 minutes.
Yes, Your Honor.
Unless there's questions, you can just go ahead and proceed.
Thank you, Your Honors. This is a case about whether an email with 11 abbreviated points fully comprised a full and complete agreement between the parties on how to divide their $35+ million estate. Below, Lisa argued that this was not a fully and completely integrated agreement. It didn't make sense that a party would dissolve their entire $30 million estate in just 11 bullet points. She argued that there were other terms, other things that were part of this mediation that were not in that 11-point email, and that the district court needed to hear evidence about that. But the district court didn't. The district court said, well, if there's no ambiguity, then why do I need to hear extrinsic evidence? And clearly that's just an incorrect understanding of the law. A court can hear extrinsic evidence when the issue is whether an agreement is integrated or not. And then the court, if the agreement is determined to not be integrated or even partially integrated, the court can hear evidence about what terms were part of the agreement that did not end up in the written agreement.
In your briefing, to me it's not quite clear whether you're arguing simply a lack of integration or whether you're also arguing a lack of enforceability other than just not being integrated. And then in the reply brief, there's even an assertion of ambiguity.
Yes.
So what are you arguing? Lack of integration, unenforceability, ambiguity?
It's a lack of integration, Your Honor, because that is what was argued below. Below, Mr. Bradshaw, Lisa's counsel, was very persistent in saying that this November email is enforceable, it's just not complete. There are terms that we agreed to that are not in this email, and then he said, unfortunately, if those terms are not added to it, then we might not have a meeting of the minds.
So do you agree that the terms that are set forth in the email are not ambiguous?
Yes, yeah, there's not an ambiguity issue here.
And do you agree that any, and I apologize for my voice.
You sound like you've had the plague, Your Honor.
I had the plague.
I'm
This is
so sorry.
post-plague, actually, but
Yes.
the voice remains. But I can sing bass, so that's awesome, because I'm a tenor. But my question is this, do you think that other testimony could vary the terms of the email?
So other testimony cannot vary the terms of the email, but certainly, under integration, you can't contradict, but you can supplement. And here, the issues that were supplemented were, first off, the email says that the cuprates need to be completely dissolved, but there wasn't any information on how they were to be dissolved, and that was incredibly complicated in this case because these were irrevocable Alaskan trusts.
Isn't that more of an enforcement issue rather than, I think what you're saying is if you have a complicated legal issue that's part of even an integrated agreement but doesn't say exactly how to do it, that somehow that makes it unenforceable, or there has to be extra terms that you get to do it the way you want to. It seems that if you say they have to be dissolved, even now with the arguments you have in your briefs that says that maybe additional things need to be done, why can't that just be handled as a matter of enforcement? And if they say that these are dissolved and nothing further needs to be done, but you think there needs to be something done, why can't that be a matter of enforcement?
Because the issue, Your Honor, was whether this was a $25 million estate or a $35 million estate. If this was
But that has nothing to do with whether they're dissolved, does it?
It absolutely does, because this house was worth $10 million, and the owners of the house were these irrevocable Alaskan trusts. It was unclear whether Lisa's trust could be set aside, because it's an irrevocable Alaskan trust and it's very complicated.
Well, I mean, it could be set aside. I thought the Alaska statutes provided different ways that it could be satisfied, or it could be dissolved.
It can be dissolved under two conditions, if all the beneficiaries consent, and if, and if continuation of the trust on the existing terms of the trust is not necessary to further a material purpose of the trust.
Right, so it can be dissolved, and I think this sort of piggybacks off Judge Mortensen's question. So if it can be dissolved, and if the November 16th email says that they agree that they're going to be dissolved, then now aren't we just at a place of like which path towards dissolution we're gonna take?
No, because it wasn't a foreshore thing that these could be dissolved. Brad's could be set aside because he was no longer
Right,
in the
living in the
home.
home.
But the material purpose of this trust was to create an estate plan for their children.
But
And-
correct me if
and-
I'm wrong, but I thought under Alaska law, if the children were given notice and the opportunity to be heard, and then there's a court order, it could be dissolved even with that, right?
No, so it's 13-36-360, that you have to have consent and if continuation of the trust on the existing terms is not necessary to further a material purpose of the trust. It's that and that is incredibly important here. So you can have consent of the beneficiaries, but if a court determines that the material purpose of this trust was to provide estate planning, an inheritance tax-free for these children, and now we're getting rid of that purpose because the parties are getting divorced, I think that a court could determine that that wasn't a material, that we were furthering a material purpose of the trust. So I
And
think.
as you interpret that statute, can the Utah divorce judge make that finding, or does it have to be made pursuant to a separate petition by an Alaska judge?
Your Honor, from what we understand from all the evidence on the record from the Sheftel Law Firm, which is the estate planning attorneys, it could be done by a Utah judge, but there need to be a petition, consent, and this particular finding. Here, we don't have a petition. The evidence on consent is super iffy, and we don't have a finding about this furthering material purposes of the trust.
But correct me if I'm wrong, but doesn't Lisa end up, or through counsel, doesn't she end up saying to the district court that the thing that the district court did in the March 2023 order complied with her understanding of how this needed to be done?
No, Your Honor. In fact, when we get to, excuse me, apologize. When we get to, for example, the memorandums before the November 2023 evidentiary hearing, it's pages like 4455 to 4459. Lisa's counsel goes into extraordinary detail about the process.
Sorry, give me the side again, I was looking.
Yes, here we go. It's like 4455 to 4459. The council goes into lots of detail about what did and did not happen. And there's no clear assertion there that how the trusts were dissolved, if that court order actually did dissolve the trust.
If that is true, that the way they intended for it to happen, they said these will be dissolved as if they could do it. And what you're telling us now is, well, that's nice that they thought they could do that, but that was wrong. Is that what you're saying?
We're saying that it's still an open question, and it's very possible that Lisa
Is
did not
that
get the benefit of the
an
bargain.
integration issue, or is that a mistake of fact issue? And if it's a mistake of fact or a mistake of law issue, wouldn't that have to be preserved?
So we've raised it under an integration issue, Your Honor, because counsel very clearly said in emails and in that very long hearing in front of the judge that this agreement was not integrated because it wasn't clear how these very particular irrevocable trusts were going to be resolved. And so that we have raised it through integration, that there needed to be more terms. And also, in addition to this irrevocable trust issue, there was a condition precedent about Mr. Wilson's health records. And it was very clear in that hearing in May of 2023, or excuse me, in March of 2023, that the only reason that the parties reached any agreement in this mediation was because Brad said that he would be willing to give Lisa his mental health records. She would be able to look at them with the assistance of a professional, and then at that point, she would be able to decide whether to go forward
That's
with
not
the
what
agreement or not.
that's not what the email says, though, right?
So the email gives part of it, right? The email gives a part of it, but the supplemental term would be what Lisa argued.
I can't remember where in the chronology of all this it came, but I thought I had read somewhere in which Lisa's counsel says to the court that what you're saying was discussed, but that they had decided to withdraw that as a provision because Brad would not agree that anyone else could look at the results of the brain scan, and that without having the ability to consult with a doctor, she wasn't gonna be able to make heads or tails of it, and so that she had then withdrawn that as a request. I thought there was an affirmative
So anyway,
abandonment
so
of
that's
it.
page 5571 of the record, I believe. And what happened, Your Honor, is that we have this November mediation, and then right after it, Brad creates the mediation agreement, and Lisa says that agreement doesn't match this email. In fact, there's a bunch of terms we talked about during the mediation that aren't included in this formal agreement, and it also changes some terms. So they argue about that for a while, and then in January, when she responds to his motion to enforce, she proposes her own agreement. And during this entire time, I believe they've been talking back and forth, council have been talking back and forth. And she says at that point, I took out this provision because I was just trying to create a document that we could get him to sign now. Now, that was in January, that wasn't in November. And in the hearing, she says over and over again, this was a crucial part of the reason we even got to any agreements whatsoever, because Lisa's very concerned that Brad was not thinking about the dissolution of the house and of these irrevocable Alaskan trusts in a helpful way. I think she was really concerned about what this would mean for her family, what this would mean for inheritance, and all of these things. And so she wanted to make sure that he was in sound mind when he was saying, oh yeah, go ahead and get rid of all of these irrevocable trusts and essentially get rid of the inheritance for the children.
So it's your position that when they walked out of the first mediation, that there was an agreement that she would get to see and share those records and then make a decision whether to go forward?
Yes, Your Honor, that is very, very well documented in the March hearing that's a proffer from Lisa's counsel.
And also walking out of the first mediation, is it your position that there had been an agreement that somebody's going to file a separate petition and we're gonna get a finding from the court and consent from the beneficiaries with regard to the trust, that was agreed upon at the initial mediation?
Yeah, so the actual steps about what they were going to do, I don't think the record is clear about exactly what was agreed upon for that. I think partially it's because Lisa's counsel felt that he was under a mediation privilege and he couldn't discuss,
Well, I
go
want
into
to
a
talk to
lot
you
of
about
it.
that. Isn't he under a mediation privilege?
I mean, the court said it was waived, and so if, that whole hearing is very complicated because counsel says things and then he's like, maybe I can't, and then I can, and then I can't. So he never goes into, and to get to your question, Dr. Luthi, Judge Luthi, I apologize.
like doctor, too.
Dr. Luthi will say it today. Judge Luthi, is that we never really got into any details about the how of.
But is it your position today that if parole evidence were taken, that the parole evidence would reveal additional terms? Because it seems like if you're arguing lack of integration, that means there are additional terms that we don't see,
Yeah.
that were agreed to, but aren't in the writing.
Yeah, so I think we've got two additional terms that the parole evidence would show. First, it's this additional term about the mental health evaluation and the go, no-go clause. And then secondly, I think we'd see some terms about how the parties were supposed to resolve the irrevocable trust. Now, I don't know if the evidence would show that they got into the nitty-gritty details, but I think there was more discussion about what the parties were to do. And that was all wrapped into the timing issue, because Brad wanted to have this agreement start immediately on December 1st. And Lisa argued that's just absolutely not possible, not with the changes you have to do to the LLCs, and these irrevocable trusts are very complicated to resolve, and it's very possible that they might not be resolved. But Lisa's might not be resolved because she was still in the house.
I'm not sure that it would matter to a decision from us, but help me think down the line, if we were to reverse and say, the district court needs to take evidence as to, whether the agreement was integrated, and if it wasn't integrated, what were the additional terms? If it turns out there was no meeting of the minds on how to dissolve, especially the wife's trust, what happens at that point?
I mean, I think at that point, Lisa would need to file a motion to have all the orders and everything set aside. I think that would require more motion work in the district court if we end up finding out through the parole evidence that there was no meeting of the minds about some of these essential terms that were not added into the November email.
How does that work with the concession you made up front that we have enforceable terms that have been agreed upon, and then if it turns out those can all be enforced, and there was not a side agreement as to how to dissolve the trusts, how do we
Yeah.
then move forward? And it sounds like you're saying, well, then we say, we didn't have a meeting of the minds.
I mean, it's a bit complicated, Your Honor, but what was argued below was that these terms, these 11 terms, we are agreeing to all of that in principle. Those are enforceable. There were these preconditions, which was the MRI, and then how to do these irrevocable, how to dissolve these irrevocable trusts. And if those two are not part of the agreement, then the entire agreement likely falls apart. And so we do have these additional terms, but they're pretty essential terms of the agreement.
This case has some concerns for me because we could disrupt significantly some pretty established things that are common in the domestic arena. One being parties mediate cases daily all over the state and all areas of the law, but particularly in domestic cases. And we have a pretty robust body of case law about settlement agreements flowing from that. That body of case law doesn't seem to be super helpful on the issue of integration.
They don't talk to each other, that's right.
Right. And so if we all of a sudden say that there needed to be an integration clause in this email, and in the absence of that, or something else indicating integration, that all bets are off, then we are going back to all of this case law about settlement agreements and where trial courts frequently have summarily enforced domestic settlements, and we're saying all of that's off the table. Every party can every time argue about integration.
I disagree.
Okay, why?
First off, we do have a lot of divorce agreements that are actually memorialized in a written agreement. So this is a circumstance where we have an email. I don't think it's incredibly common to have emails settling $30 million estates. Oftentimes these divorce mediations result in some sort of signed agreement afterwards. So I think that resolves it. Secondly, if there had been different terms in these emails, you're right, Park Place and a bunch of other cases have come out that have upheld emails from attorneys settling a case. It really depends on the language
Although,
of the email.
frankly, in those cases, it's the other side who's usually saying the email's not enforceable. In this case, it's your side saying our email's not enforceable, right?
Well, we're saying the email is enforceable, but there's additional terms.
Right.
And the email was from us, but Lisa wrote it, and then Brad's attorney came in and tweaked it, and then it was sent. So it was a combination.
Back to my main thing about how disruptive this will be.
Oh, I don't think it will be disruptive at all, Your Honor, because you could put in the emails that this is our complete agreement. This is how we're going to resolve all of the marital things. There's simple
Right, but
language
all
that
of
you
our
could put in.
cases where that didn't exist now we would say if there isn't an integration statement in the email, that then it's open to have this discussion about integration.
Well, remember that the integration case law doesn't require you to have like an integration statement. You look at the context of the email, you look at the context of the agreement, and you look at if it's fully resolving all of the parties' concerns. So that's the question, and I think it's important, especially in settlement discussions, when they're happening late at night, and you're just trying to memorialize the point to which the parties have gotten that day, that we're not enforcing just these bullet-pointed emails, especially for a $30 million estate. If this were a business transaction, a $30 million business transaction, we would never let it stand, because it just doesn't happen this way. So I don't think we're going to be disrupting. I think we have very established case law on can attorneys send emails and bind their clients to a settlement. I think we've got case law on that. We also have very established case law on what integration means and when it shows up and when it doesn't. They oftentimes are not talked about together, but they work together, and they have to work together, because we don't want attorneys sending off emails that only give two provisions and not allowing the clients to come in and say, wait, we actually agreed to a lot more in this mediation. And interestingly enough, all we're saying is that all this judge needed to do was take some evidence on whether this contract was integrated or not. And if the court made findings and determined that it was, case closed. So it's not like we're disrupting everything. We're saying that the court needed to take that first step and take evidence about whether it was integrated and then move on from there.
Is there a mediation privilege?
To be very honest, Your Honor, I didn't delve into it because it was not an issue that was raised, but I believe the court said that there wasn't a mediation privilege because a lot of the stuff happened
I wasn't
after
asking
mediation.
about the district court, I'm asking whether it exists.
Oh, whether
The court said it
even
was
exists.
waived,
Yes,
and that was gonna be my next question, was the court wrong?
I believe there's a rule of evidence which I can look up that says.
It's a
that
statute.
A statute, see, I apologize. I
It
didn't have
actually
my short.
says that if judges review evidence which is covered by that privilege, that conflicts us off the case. It's that strong.
Yeah.
In my reading.
Okay,
It's the folks down the hall said that. So.
it's pretty strong. It is, of course, not an issue we've raised here, but certainly, I think that we've got some pretty clear issues with this contract simply wasn't integrated, and the court needed to do more than just say it wasn't integrated. The court needed to take evidence before it made that decision. I see I'm out of time. That's the question.
Thank you, and we kept you over, so you'll have your full 3 minutes on rebuttal. Ms. Nelson.
Thank you. I would back up a little bit and say this is a case about how a $30 million estate was divided in half so that everybody got $15 million pursuant to a settlement agreement that the trial court found was enforceable. And importantly, both parties have already received the benefit of their bargain. One thing that didn't come up at all in Ms. Adams' presentation is that record 4280 to 4287 shows all of the documents related to the QPRTs have already been executed. And the property is solely in Ms. Wilson's name.
Did the kids, I didn't get deep enough into the record to answer it, to figure out the answer to this question. Did the kids get notice and the opportunity to push back?
That's not quite the right question.
Okay.
Here's the right question. The question is, Ms. Adams talked about 1336-360, which does talk about notice to the beneficiaries, and there was a discussion about, yes, the kids have been notified, but that's not the operative statute. And it's not the statute that Judge Mrazek ruled under. The operative statute is 13-36-345, which doesn't say anything about notice to the beneficiaries. It says, on petition by a trustee, settlor, or beneficiary, a court may modify the administrative or dispositive terms of an irrevocable trust or terminate an irrevocable trust if, because of circumstances not anticipated by the settlor, modification or termination would substantially further the settlor's purposes in creating the trust. That was the provision that the apparently all-knowing Shaftel firm recommended that they move under. There was a specific question by this court about whether Judge Mrazek could do it, and the answer was undisputedly yes, Judge Mrazek could do it.
Does he need to enter findings about various things you just read, circumstances not contemplated?
He can just say that he did it, that the circumstances had changed, and, and importantly, as was referenced, Lisa told the court it did what she wanted. It did that, she did that at page 3807, that's her Rule 60B motion, and a footnote making clear that the court adopted Lisa's proposal. At 4458, Ms. Adams referred to that discussion, that's true. I would specifically point you to 4458, but she's right in the general range. 4444 and 5927, which is a transcript. And the court said, and there was a disagreement about how to eliminate the QPRTs. Ultimately, the court adopted Brad's view of that, correct? Mr. Bradshaw, no, the court adopted Lisa's view of that because the difference of opinion was the court adopted Brad's version of how his QPRT could be eliminated. That was not what the Shaftel firm advised, that was not going to work with respect to Lisa's, and the court entered an order under the Alaska statute that the Shaftel firm had recommended, eliminating the QPRT or Lisa's QPRT pursuant to court order. That's 5927. So I don't think there's really any question that the QPRTs have been dissolved pursuant to 1336-345, didn't require beneficiary consent. Judge Mrazek entered an order, the order that Lisa told him he should and could enter. He did it, and the parties followed through with those steps.
What's your position on the idea that there would need to be a petition and whether the divorce action qualifies as that petition?
That's a great question, and I have thought about it, and here's my response. One is that, I have like a few responses. One is that Lisa's never argued that that was, I want to say, a jurisdictional requirement. I'm not sure I'm using that word correctly, but do we actually have to have a petition? And I looked briefly, I couldn't find any Alaska authority saying that it had to be done that particular way. What I think matters is that just in the abstract, if somebody wanted to dissolve a trust, they've got to come to a court somehow. Well, they had come to the court. There was ironically, a petition for divorce, right? There was an active court case. If Lisa felt that there needed to be a petition, she could have filed one. She probably could still file one, and Judge Mrazek could nunc pro tunc say, okay, now there's a petition. I don't see where
Isn't
there's.
the issue, though, whether the beneficiaries may come later and try to challenge the dissolution of the trust?
That's not how I read 1336, 345, and she hasn't given us any authority to the extent that that absolutely has to be done. Additionally, Brad doesn't have any control over what Lisa's going to do. Everyone agreed it was easier for Brad to dissolve his than for Lisa to dissolve hers, but he can't control what Lisa does. And let's remember that Lisa kept saying and has said today that dissolving the QPRTs is really complex. That's not true. It actually was done relatively quickly. It was a few pieces of paper. Mr. Bradshaw had represented up front that it could be done by the end of the year. That was starting at around Thanksgiving. It could be done by the end of the year.
I want to come back to my question, because I'm not sure that I got an answer that I was hoping for.
So my point is that Brad couldn't control what Lisa did. If Lisa felt like a petition was so necessary, do it.
My question is about the beneficiaries, and that if Brad's got his share of the marital estate,
Right.
and Lisa's concern appears to be, I'm not sure whether I have my share of the marital estate, because there's an open question that the beneficiaries may come and challenge the dissolution of my trust. And if they're successful in that, then I'm not going to have what we bargained for under points 1 through 11. And that's why I walked out of mediation thinking we had an agreement as to how to dissolve my trust in a way that I would feel more settled, that I was actually getting the home. Why is that argument not?
For a couple of reasons. First, I understand that's what she's saying now. That's not what she said in the email that she drafted, that was the settlement agreement. When she goes to Judge Mrazek and explains that this is not fully integrated, that discussion is really interesting. It's at 5531 to 5541. There's 10 pages, and the only thing that's being talked about in that section is the neuropsych evaluation. Now, as was discussed when Ms. Adams was up here, the cases about fully integrated don't mean I had afterthoughts, or I had regrets, or I wish I hadn't agreed to it that way, or I wish we had done it a different way. Those cases are about whether there's another agreement, a side agreement that didn't get incorporated into the email.
Or a side provision that didn't get incorporated.
Or a side provision, something, not just, oh, dang, I wish I hadn't done it that way. But that's what's being presented here today. And
But suppose, this sort of echoes, I think, Judge Luthie's concern. Suppose that Judge Mrazek had said, okay, you're right, there's this question about whether this is integrated. I'm gonna let you put on evidence about the neuropsych thing. And suppose Lisa gets on the stand and says, no, this was the agreement. I always had the ability to back out, depending on the results of this thing. Why doesn't she get to put on that evidence?
are we shifting away from
I guess
the
I'm sort of
petition?
shifting.
I think
I
it's
wanna
the
make
same.
sure if-
I think it's the same question, but the two different possible provisions that may be
Okay, well, I think they
extraneous
have
to the
really different
email.
answers. Because the neuropsych is the only one where this actually gets presented to Judge Mrazek as an issue that I believe there is, I, being Lisa,
Yeah.
think there's a side agreement on, okay?
Right.
And Judge Mrazek's thinking there is mediation privilege here, right? You're talking about things that were discussed during the mediation, and in those pages, 5531 to 5541, Mr. Harris is making objections about mediation privilege, but the QPRT, the petition piece, is not in that discussion. The fully integrated piece as it relates to there's no fully integrated discussion in the trial record about the QPRTs. And we can see that when we look at the sites that they have offered in their brief for showing that that argument is preserved. They're not there. They don't support that position. They do have sites for the neuropsych eval. I'll give them that. Just that one site, but they
So
do
your
have
answer to
that.
my question is they haven't really preserved the idea that there's a parole agreement as to how to dissolve the.
Yeah, yes, and I think the reason they haven't preserved it is because there wasn't. I mean, that's what I see happening here. That they didn't preserve it. There wasn't a side agreement. Those 7 items that Lisa lists in her brief, the only one that there was discussion of is a neuropsych. The others are all things that seem to be afterthoughts, things that, well, I thought this, I wish this, but we didn't have an agreement on that. I mean, there's no evidence that Brad's side ever agreed to Lisa's proposal, and there was significant discussion later on about the QPRTs, including, Judge, you need to do it this way. Okay, I'll do it that way. Great. We've gone through, we've signed all the documents, it's taken care of. Like, you don't get to appeal now and say, well, I think maybe the judge didn't do it right, even though he did it the exact way that I told him to. That's not what an appeal is for. That's a waiver, a judicial estoppel. You walked him into this scenario. He did exactly what he was asked to do. You don't get to appeal that.
I'd like to ask a kind of bigger picture question that is maybe the flip side of one that Judge Mortensen asked to Ms. Adams, and that is, if we take the combination of, well, really the mediation privilege and say here, even if you're now saying, Lisa, that there was a parole agreement about looking at the neuropsych documents and that was a condition precedent to the rest of the agreement going forward, that, well, you can't talk about that, even if we were to say, yep, we see no integration clause. But we can't take evidence because the evidence you want to offer will come from your mediation discussions. Then is the result of that decision that parties will realize we should never put anything in writing about a mediation until we can put it all in writing. Let's not go home in the evening and document, here's where we got to, because we put that in writing and somebody's gonna say, that's our agreement, and you mediation privilege says you can't add anything to it.
Well, or how about a sentence that says the parties will continue to discuss how to effectuate the dissolution of the QPRTs? That's a really easy solution. Put that in your email. If you're intending to draft a further document, I mean, no, I don't think you have to tear down the entire structure here. You can advise people, yeah, you've got an integration clause, how about a non-integration clause? How about this issue remains open and needs to continue to be discussed? I think we've got
But
to.
then that would become very crucial, the attorneys remember to do that.
If they're going to, well, sure, but that's common in contract law. Don't forget to put that
But
piece.
I'm just
Right.
wanting to make
Sure.
sure that I understand.
Sure, I think there's a risk when you walk out of a settlement with not a signed document that the next day somebody will have some regrets, or they'll back out, or they'll try to think of ways to get out of it, but that's not what we're going for here. Judge Mrazek found that it was enforceable as to all those provisions, including, let's keep in mind, that the QPRTs would be dissolved. And then he did that. So, whether there needs to be a petition filed, that's not in the email that Lisa wrote. It wasn't presented to Judge Mrazek. Some of the other things that she brings up in her brief are like, the last one was that there are other things that weren't in the agreement. Okay, that's not an integration issue. You didn't include everything in the context of your discussion. You don't get to appeal that on the basis of an integration agreement. The point is you have to have a side agreement or a side provision or some other provision that was coming in. I'm kind of rambling now. I don't know if I answered your question.
Can I take you to the sanctions issue?
Yes.
Unless there's more? Okay, I've got a particular question about the sanctions issue. As I understand it, there's sort of two things going on in that issue. There's the valuation of the Fidelity accounts, and then there's this question of whether Lisa should have to pay the January through April LLC amounts. The LLCs were paying toward the mortgage,
Yes.
right? I'm gonna ask you about the second one.
Okay.
as I understand how this all played out, the district court was essentially faulting her for litigating, for responding to the motion to enforce and for litigating these various integration questions. And that's essentially why he's holding her responsible for the January through April mortgage payments. Do I have that right?
I think that's a fair characterization.
Why can't she litigate that? Why is she on the hook for responding to Brad's motion to enforce? Why doesn't she have the ability as an affected litigant to push back when she has a good faith basis? I guess really, let me just go and ask the question that was gonna be my third question in this Socratic dialogue. It feels to me like Judge Mrazek would need to have made something like a bad faith finding, that she wasn't litigating in good faith to justify this. Because if she's litigating in good faith, and it takes Judge Mrazek until March to actually issue an order saying, here's when you're gonna close on everything, then I don't know why she's on the hook for the January through April mortgage payments. That's what I'm wondering.
Okay, well, I think you've maybe presented that better than was presented in their brief. And, which is not actually my, like,
I'll
they
take
didn't bring it up,
Yeah.
but,
That's how I understood their brief, though. That's
okay.
how I understood their.
all right, fair enough. So what Judge Mrazek says is that, well, first off, let's keep in mind that there was no discussion about the transfer of the LLCs. Never, right? That was never one of the things that she wanted to pull apart, except to the extent that she had the idea that they were all going to be resolved on the same day.
Yeah, I mean, there's this fight about timing. I mean, so let me go and reframe the question perhaps even better than I just did. There's this fight about timing, and she's saying all along, look, we don't have in that November 16th email, there's nothing about timing. So let's figure out timing. And so then they're going around and around on timing, and it's not until the March hearing where Judge Mrazek settles that, and he says, all right, look, the law implies a reasonable time. 45 days seems like a reasonable time based on your prior representations, so everything needs to be done within 45 days, and then they get it all done. But then he comes back and sanctions her for the mortgage payments from January through April, but we don't have a ruling from him setting out the timing until March. So why is she on the hook for the January, February, March mortgage payments?
Well, I would say that Judge Mrazek's position was that there was never any discussion about, like I said, there was never any discussion about whether the LLCs could be transferred. She's saying all along that there was no discussion of timing, and she's saying that now that was one of the integration problems. But as early as the week after, the couple of days after mediation, when Mr. Harris said, let's get it done by December 1st, she said, no, let's get it done by December 31st. And
right.
some of those transfers had started to happen. And so that's why, because Brad had started to do his side of the deal and she was getting the benefit without having to carry her side of the deal, that was why Judge Mrazek felt that she needed to carry those burdens. I mean, in order to equalize what had happened. Some of the transactions had happened, but not all of them. And then in March, there were additional layers where Judge Mrazek found all of this could have been done. You're delaying, I'm not going to do this. I mean,
But from her end, part of it is that the QPRTs need to be dissolved for her to get the benefit of her end of things. And that doesn't happen until Mrazek, right? That doesn't happen until the March order, or does it?
that's true. So in January of 2023, she issued a settlement agreement saying everything could be done by February 15th. And then by March 15th, Mrazek says, okay, I think 45 days is a reasonable amount of time to get everything done.
Right.
And it all gets done within 30 days. And Mrazek uses that to say, so you could have done this by December 31st. And Brad has started to do some of his transactions. And it's not that the entire thing needs to be done. That was never contemplated in the email by Judge Mrazek, by Brad's side, that everything needed to be done simultaneously. Lisa was the only one who offered that theory. But as pieces start to be done, like the LLC piece itself, that was done. So, but then Lisa needed to carry that. And then the fidelity piece, do you want me to talk about the fidelity piece?
Before you do that, when did Judge Mrazek make his finding of a change of circumstances such that the trust?
I think that order is signed in April of 2023. I think he made it
Orally in March, right?
orally in March, and the order is signed in April of 2023.
And it's effective as of March, right?
Yeah,
Yeah.
that's right. we would ask you to affirm.
Thank you. Thank you, Ms. Nelson. Ms. Adams.
Just a few quick points and some record sites. Talking about Alaska statute 13-36-345 that council was talking about requires circumstances not anticipated by the settler. And then also requires a finding that termination substantially furthered the settler's original purpose. Here, there actually is a provision in the irrevocable trust on page 3636 that contemplates divorce and says what happens in the context of divorce. So I think it's still very much an open question about whether this is-
Can't she waive that though? I mean, if she says to Judge Mrazek, you did everything I asked you to do, can't she waive that?
The problem is the beneficiaries, and there are some, and the issue is, yes, so there are some deeds, and it has her name on it, but the problem is it doesn't insulate her from further litigation.
But then wouldn't she have a claim against her attorneys then for waiving that on her behalf?
But the problem is, Your Honor, is then she is not receiving the benefit of her bargain. Then that means that this was a $25 million estate rather than a $35 million.
Well, I mean, in theory, she does right now, because if Judge Mrazek has dissolved the QPRTs, then they're dissolved. And if the beneficiaries want to come in later and sue to sort of undo that, then there might be some downstream litigation. But at the moment, there's no such litigation. So correct me if I'm wrong, but at the moment, the QPRTs are dissolved and she has to house free and clear.
Well, at the moment, it's unclear whether the QPRTs are dissolved, and certainly the beneficiaries could bring
I mean,
a
how could
quiet
that
title.
be the case though? We've got an order from Judge Mrazek dissolving them.
He has an order, but the problem is the order doesn't follow Alaska statute 13-36.
But nobody has said that in court. And so if somebody comes along in court and says that, now we've got a new lawsuit. But at the moment, legally, right now, they're dissolved, aren't they?
I don't think it's very clear that they're resolved. I think it's an open question, and that's one reason why Lisa is here today, is because it's not clear.
Sorry, did Lisa make this argument to Judge Mrazek that there was a parole agreement as to how to dissolve the trust?
So
And we need to take parole evidence to show that to you.
So I'm gonna give you some sites, and they're pretty similar to what Ms. Nelson has done. It's on page 5535, council says there are multiple terms. There are multiple terms that are conditions precedent, but doesn't go into them because of the mediation problem. Then he talks about communications about the irrevocable trust on 5544 to 5546. And then, of course, we have all the emails from 3294 to 3300, where they're talking extensively about how we're going to close and what this means. So it's not incredibly clear, Your Honor. There's not a clear proffer that says, we talked at the mediation about these three things. The proffer isn't nearly as clear than as we have about the mental health evaluation. But certainly I think that there are pieces in the
Additional
record that
terms.
potentially point to that, and because they weren't able to offer extrinsic evidence on that, that's problematic.
If the mediation privilege is as ironclad as Judge Mortensen suggests, how do you get around that? What evidence could you put on of parole terms if you can't talk about what was discussed at mediation?
Your Honor, I'm not prepared to answer that today, but I can certainly do a 24J letter if we get to that point.
Looks like there are no additional questions.
Thank you, Your Honors.
Thank you both for your arguments in your brief and your arguments here today. They've been helpful. We'll take the matter under advisement and get out an opinion as soon as we can, as we always do. With that, we will excuse counsel from this matter and invite counsel for our next matter.